Welcome to the Ask the Expert Show with local celebrity hosts Steve-O and Renee. Sit back each week while Steve-O and Renee educate you with live in-studio experts, such as lawyers, doctors, home improvement, and financial experts in their field. Call in and have your questions answered each week at 888-565-1470. Now, here is Steve-O and Renee with today's expert in their field.
Good afternoon. Another week without Renee. She's working on our morning show, but now it's not just the Steve-O and Renee show. It's now the award-winning Steve-O and Renee show, as Renee and I won New Times Reader's Choice Best AM Radio Personalities. This is the first Thursday of the month. I got to get my day straight. Whenever we have the first Thursday of the month, we have our association show on. And today is kind of strange today because we've had both the senior partners, both Robert Kaye and Michael Bender, on for the last 2.5 years. Today, again, this is the second time in 3 years, we get to have another senior partner with us. You always hear his name. The name of the firm is Kaye Bender and Rembaum. This is Rembaum, Jeffrey Rembaum. Good to see you for the second time in almost 3 years.
Good to see you again.
And you brought your lead associate attorney in with you.
I did.
Danielle Brennan.
I did.
Of the Brennan Breakfast people in New Orleans, right?
Actually, no, the Brennans of New Hampshire. But
that's what I said, didn't I? I said New Hampshire.
I heard New Hampshire.
Anyway, we're going to talk about association law today, and there's some new things out on the books that we're going to talk about. If you want to call the show today, call us at 888-565-1470. That's 888-565-1470. So if you are the president of your association, you're a board member, maybe you manage a group, you definitely want to call today. Any question is fine. 888-565-1470. Let's talk about the firm first.
Okay, but I also want to add, even if you're an owner and not on the board and you want to call in, you too are welcome to call in.
See the difference in the shows and the senior partners? See, he wants everybody to call in.
Everybody's welcome.
So tell us about the firm. Especially for new people, this is the first time they've listened.
We are a community association law firm, 15 lawyers, about 30 staff, whose 99% of what we do every day is representation of community associations around this great state of Florida.
Well, you guys are so good. You are probably one of the biggest in Florida, because I know how many clients you have.
Well, I appreciate that. I don't think we are the largest, but I do appreciate that. We're probably second or third.
See, he's very humble. Today, we have a lot of things we're going to talk about. We got classes we're going to talk about. Now, you're in the Palm Beach Gardens office.
Right.
You also have one in Pompano.
Yes, we do, right off Copans Road, and our Palm Beach Gardens office is conveniently located between I-95 and the Turnpike.
So if you have a phone, if you have a message, we've already got our first caller.
We have the first caller.
Wow, before we even started.
Dad, I told you to wait at least a half an hour.
It's cousin, I thought.
Oh,
it's cousin.
could be. Right.
Cousin Matt is on the phone.
Right.
Hi, Matt.
Hi, how are you?
Good. You have a question for Jeff Rembaum?
Yes. I'm a general manager for a large community in Boynton Beach, and I'm calling about the fire sprinkler retrofitting requirement. And I've gotten information from not only the city of Boynton Beach fire marshal, but also the state fire marshal that they're not going to do anything at all with it for any condominium associations that are below the 75 feet mark. So I'm just trying to get confirmation or information on it.
Sure, I'd be happy to talk about that. In fact, Steve,
new law, right?
Excuse me?
It's a new law.
Well, it's an old law that was recently revised.
Okay.
And it's created a lot of confusion because the old law dealing with fire safety sprinkler, you either had to retrofit your building with the fire safety sprinklers, or you could take a vote of the owners to not have them. Fine. But it was applicable to buildings 75 feet or higher. In the Life Safety Code, a high-rise building is defined as 75 feet or higher. In Chapter 718, we humbly refer to as the Condominium Act, the legislature recently took out the requirement, the language about the fire safety sprinklers and the retrofit and the need for that vote to buildings that were higher than 75 feet. They took out the reference to the 75 feet. So does that then mean that the need to take the vote of the members or do the retrofit applies to all condominiums in the state, or just those 75 feet or higher? Because as Matt just told us,
they just took that out, though.
Some of the fire safety inspectors, fire marshals, will say no, it only applies to high rises. But the Director of Communications for the Florida Division of for the Florida Department of Business and Professional Regulation has said it applies to all condominiums. Matt, did you hear that? DBPR has put out a written statement that I read with my own eyes. It said it, and it was actually sent to me by a reporter, where DBPR said it applies to all condominiums, even those below the 75 feet mark. With that in mind, we do have a conundrum, right? Which one are you going to follow? I think the smartest thing to do is take the vote of the members. Either do the retrofit or take the vote. Why not? Because one thing for sure, Matt, even if the fire marshals are correct in how they're looking at this, if, God forbid, someone has a fire, you know the personal injury lawyers are going to look right to that law in 718 and say, okay, show me the records for what this association did for the retrofit. And if you can't show that you took that vote of the members to opt out, I certainly would not want to be one of those board members. So it is a conundrum. We don't have certainty in the law. And if there are any legislators listening to this show, and I hope there are, please fix this problem for your constituents. It needs to be fixed. Direction needs to be given in the legislation. So thank you, Matt, for asking that question. It was a great question.
I appreciate it.
Thanks for calling, Matt.
Did that answer for you?
Yes. Thank you.
You're welcome.
So I understand there's some big news
There is.
for community associations.
Danielle got married recently.
That's
I
great
did.
news. Mm-hmm. Congratulations.
Thank you very
she's still
much.
new.
Should have brought her here and had just done it right here on the show.
That would have been cool.
Yeah.
I don't know if she would have wanted that.
The room
though.
is a little small.
Doesn't matter. This is what you invite everybody. They're going to get the invitation. They're going to go, I don't know her, but we better send a present in case we do.
Is that the big news you were talking about, or
Nope.
was there other big news?
You have big news.
I have big news.
Community association.
You want to talk about Quadomain, don't you?
Well, I want the one that's on the legal morsel on your website.
Yeah.
Because we get a lot of emails, people
Right.
going, they love reading that. Give everybody your website address.
kbrlegal.com. kbrlegal.com.
So we're going to talk about the most recent article on there.
Sure. There's actually two articles in there. One is Legal Morsels, and that is Robert Kaye's article. The other one is Rembaum's Association Roundup. That's my article. So we both sometimes we both cross over each other a little bit, and you get two different perspectives of the same issue. And we pretty much say the same thing using different words.
So what is it?
All right, so a lot of people don't know what happened back in December 2012 with a little old case called Quadomain. And in that case, Quadomain addressed a situation where an association was ready to file a foreclosure, an assessment foreclosure, but there was already a pending lender foreclosure. And the appellate courts held that the association had to bring their claim in the lender's foreclosure action. To make matters worse, there's a lis pendens statute. For those of you who may not know, I'm trying not to use fancy words, but I can't avoid that one. A lis pendens, if you're going to file a lawsuit against a piece of real property, you record a document in the county's records that puts the world on notice that if you do buy or acquire this property, you take it subject to the outcome of the lawsuit. This other legislation said you also had to bring your lawsuit within 30 days of the filing of or recording of the lis pendens. So not only did you have to bring it in the lender foreclosure action, ostensibly you also had to bring it within 30 days. So in plain English, what did that do? It wiped out the association's ability to foreclose an assessment lien if the lender was already foreclosing. So what if the lender forecloses and stalls their case? The association was without remedy. So it wasn't good. And not only that, but even if they didn't stall their case, still the association was limited in what it could do. So we had to deal with that since December 2012. And Kaye Bender and Rembaum was particularly concerned about that case. And we finally had a case of our own that we could bring in to try to limit or to try to basically wipe out the holding in Quadomain. And we were very successful with that. The same court, the Fourth DCA, clearly stated that the declaration for the association, because it is recorded first, it is a recorded instrument in and of itself, so therefore you can bring the association's assessment foreclosure action, and they're no longer limited by Quadomain. It's obviously a lot more complicated, and I'm trying to keep it really simple.
How'd the case turn out?
Excellent for associations around the state of Florida, because now the associations have the right, once again, that they always should have had to bring their foreclosure action, even if the lender has brought their action. But this is the little key that really wasn't talked about very much that I am concerned about. Many declarations have very particular language in it, and it says that the lien recorded by the association relates back to the date of the recordation of the declaration itself. I would think you need that very special language in your declaration. So if you don't have that language in your declaration, you probably want to talk to the association's lawyer, and next time you amend your declaration, think about adding that, because it will help perfect and help you use the Jalali opinion to your benefit.
Now, you do the Rembaum Roundup.
Yes, sir. Rembaum's Association Roundup,
Associate. And just tell us about some of the articles that you've written.
Well, Rembaum, oh boy, wow. 5 years, every 2 weeks. New court cases, how they affect associations, new laws, and how they get interpreted. And oftentimes folks email me with particular issues they're experiencing, and I will, address those. You can go to our firm website, kbrlegal.com, scroll down to the Roundup, and it will take you to the Rembaum Association Roundup homepage. And there, if you have a particular issue, there's a search on the upper right-hand side. You just kind of type in your keyword, whatever it is, and you'll pop up every article ever that I've written on that subject. So it's a great educational tool, and it goes out around the state.
So now, let's give everybody the phone number. It's 888-565-1470 if you'd like to call in here. If you have a question for either Jeff or for Danielle, 888-565-1470. Let's talk about some of the popular classes that you've got coming on.
Sure. Absolutely. I'll first talk about Pompano Beach, and then I'll talk about Palm Beach Gardens. Pompano Beach on Tuesday, August 23rd, we're doing a Homeowner Association Board Member Certification class. On Tuesday, July 19th, in our Pompano office right off Copans, we are doing a Covenant Enforcement class. The legislature made some pretty drastic changes to how an association does its covenant enforcements, so you might want to come to that class. On Tuesday, August 9th, there is a Fair Housing Act seminar. Assistance animal or pet? ? On Tuesday, July 12th, guest restrictions and screening. Tenants and new owners, is it worthwhile? New classes there. Palm Beach Gardens, Wednesday, July 13th and August 10th. Homeowner Association Board Member Certification class. Call now, July 13th or August 10th. Those classes fill up early. Condominium Association Board Certification, July 20th and August 17th. And finally, guest restrictions and screening, Wednesday, July 27th and August 24th. Whew.
Tell me about the guest restrictions and screenings, tenants and new owners. Is it worthwhile? Tell us about that class.
Would you like to live next to a pedophile?
Nope.
Well, that's why you want to go to that class. You want to learn what you can enforce and what you cannot enforce. Questions you can legally ask and questions you cannot ask. Danielle, can you think of any questions that you can ask or can't ask?
Well, with regard to disability, there are certain questions that you can't ask, like if someone is purchasing, has a disability, or if you're the extent of that disability, nature, severity, things like that, or of the Fair Housing Act would govern things like that.
Does this get into pets?
Pets are not assistance animals. They are pets.
Okay. Does this include assistant animals?
It can absolutely include assistance animals.
That seems like it's the biggest question, because
What's
I went to one of your seminars.
Yeah.
Great seminar. It was a 2-hour seminar. And I thought, there's no way there's going to be 2 hours worth of questions. We could have gone 3 hours.
Easily.
Mm-hmm.
Easily. But the number one thing was assistant animals. And now a lot of times you go, because Renee, her parents have a community, first thing it says is no pets.
Right.
Can they say that?
Well, they can say no pets because the assistance animal is not a pet. The federal legislation has done Florida's community associations a great disservice. I want to give you an example. Let's say you were mauled as a child by...
Wait, I want to hear this. Let's go to break.
Okay.
We come back. You got a full 15 minutes. We're going to go to break. We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender and Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender and Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant tenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
And then kind of adjust.
And we are back. We have one sort of rookie and one rookie today. Now, I understand.
Rookie? Do you have any idea how many radio shows I've been on?
I couldn't tell by
don't.
your voice. But, you know, we ought to really say hello to Robert Kaye out there.
I think we should.
And Michael Bender, because I heard Robert's under the weather.
Yeah, and last I saw Michael, he was on an airplane
He's always on an airplane.
going somewhere.
So those are the two senior partners. And guess we always talk about Ann Rembaum. Well, here's Rembaum.
Here's Rembaum.
Jeffrey Rembaum. And we have Danielle Brennan, not related to Brennan of New Orleans. They are community association attorneys. And let's tell her, because we have a different audience every 15 minutes, tell everybody a little bit about the firm.
Kaye Bender and Rembaum is a firm that is exclusively devoted to representation of Florida's community associations and all the issues that they
Robert told me
encounter.
he started the firm, and he just hired you the last year or so, you and Michael, but he's the one who's developed the entire firm.
It's true. Robert did hire Michael. I wouldn't necessarily say that Robert hired me. We sort of merged our cookies together.
Okay, I kind of...
Yeah, I saw you ad-libbed that one. But there's no doubt about it. Robert is the brainchild behind this, and he built this firm. And then he built it with Michael, and they were kind enough and gracious enough to let me join in and play with them, too.
Well, we get emails about Robert, people going...
I'm sure.
I love the way he explains things. He's
That's
like
nice.
a teacher. I mean, that's
He
a nice compliment.
And he likes that. He likes teaching.
So we're talking about the firm. Now you have an office in Pompano, and the office you're in is in Palm Beach Gardens.
That's right. You picked it up. Palm Beach Gardens, conveniently located between the Turnpike and I-95, and our Copen's office is it's conveniently located, too, right off of 95, but very convenient to the Turnpike as well.
Now, you cover also as far north as, because we go as far north as like Jupiter.
Oh, I go
Stewart.
farther north than you do. In fact, my client base runs the state of Florida, from Miami all the way up the East Coast and then over to the West Coast, over to Tampa, down to Naples and beyond.
Okay,
So, truly.
give everybody your phone number because we have a lot of people listening today.
Phone number in our Pompano office is 954-928-0680. Phone number to the Palm Beach Gardens office is 561-241-4462. And you can really reach any of us by calling either of those numbers. Just make sure you ask for the person you want to speak to. And then we can route the call.
And then if you want to call us here, you can call us here at 888-565-1470. 888-565-1470. We've got another call. We've got Jessica on the line.
Hi, Jessica.
Hi.
You have a question?
Pardon?
You have a question for Jeffrey?
I was wondering, can a condo board arrange to have the monthly dues be paid 2 months in advance? And how, as a board, can we arrange that?
I don't know that it would be 2 months in advance. If the expenses are coming up, are you saying that for January's expenses, they want you to pay that in November? I'm not really sure. The question is a little out there. I need you to give me a little more detail so I can help you out there.
I guess that would be the time frame.
What's that?
That would be a good time frame, the 2 months.
As long as the association properly adopts its budget on a go-forward basis, it can then levy the assessments against the members. As long as the budget is properly adopted, the association can then levy the assessments properly against the members. If it's set up correctly, it's really not 2 months in advance, because my association, and I've been on the board, I can't believe this, I'm in this line of work, and I'm on the board of my HOA for the last 6 years. You would think I'd know better.
You should be president by now.
No, I have no desire, no. I'm that cantankerous board member that gets to sit in the back of the room and ask the hard questions. But obviously, the association could not assess for monies before the budget is adopted. But I might end up paying money in January for an expense that doesn't come due or an expenditure till November. It's entirely possible that could happen. I pay my assessments, and we need a new swing set. So the money is sitting in the budget. Well, how did that money get into the budget? So I don't really think it's a question of 2 months in advance, really, as long as the assessment relates back to the budget that was passed by the board.
Gotcha. Okay.
Does that answer your question?
Yes. Thank you so much.
Thank you for the question. Thank you for calling. By the way, Danielle, did you know that we are in the presence of greatness this afternoon? Because I know
So
he's
I've
humble.
heard.
Exactly.
Don't even
Steve
go
O and Renee were nominated and won by
Won.
Next Times, right? To be
New
what?
Times.
What was that? What are you now?
We're
the best radio
AM
personalities?
personalities.
Wow.
We were up against some guy named Rush Limbaugh.
Yeah. Never heard of him.
Never
so,
heard of him.
Okay.
Anyway, thank you for saying that. It was quite a surprise. So now I want to go to, there's a new Community Association assessment report about delinquent assessments to credit reporting agencies.
Well, there is. It's always sort of been available for the foreclosures. And if an association was foreclosing, then it was a prime target to show up on your credit report. But what about if you're just late with your delinquent assessments? Could that show up on your credit report?
Do they report that?
Well, they're apparently trying to make inroads to come up with a better system to do just that.
But is better system better for the people who live there, or is it better for the board?
Ultimately, the goal is to get people to pay their assessments. That's good for the board, so they have the money to do what they need to do. If they have the money that they need to do and everybody's paying their fair share, then it's good for the members too. But the goal is collection of the assessments. The goal should not be to embarrass, to annoy a member because they are delinquent.
Okay.
We can come back to that in a few.
Yeah, because I have a couple other questions,
Sure.
follow-up questions. Let's go to Sandy. Hi, Sandy.
Hi, I have a couple of questions.
Good.
First of all, I'm a property manager. I must disclose that. And I have a treasurer that's just admitted to, and I'm a new manager to a new community that's admitted in a members meeting to putting $10,000 in the budget last year for a lawsuit against a specific homeowner. And my question to him is how did you propose the members would ask you questions about that being a specific line item? He could not answer me and has put that in a budget with unbeknownst to the owners. And the owners were never made aware of a pending lawsuit in 2015 that commenced the same lawsuit. What kind of actions do we have? I've already filed one letter to the state.
Well, I need a little more explanation, and I'll explain why. What I've heard from you is that the association either has a lawsuit or a pending lawsuit, and it's assessed its members to fund the litigation. So that in and of itself is not unusual. So I know that I must be missing something in your story.
Okay, well, in 2015, the lawsuit commenced, unbeknownst to the owners. Then the rumor mill started through the community that there was a lawsuit and whatever, but the owners were never made aware of this lawsuit, and they were never made aware that $10,000 was specifically put into the budget, into the 2016 budget, and they will not disclose how much money is being spent or has been spent in 2015. And or what money has been spent in 2016.
Clearly, the association had to have some kind of notice of the litigation because you've said that it was a line item in the budget, and every member has a right to see the budget.
It was not a specific line item in the budget. The treasurer admitted putting in $10,000 in the budget for legal fees as a general item, not a specific line item for a specific lawsuit. And they retained a different attorney than the association's attorney, unbeknown to owners.
Okay, the retention of the attorney should be done at a regular board meeting. The retention of the attorney is not in and of itself, typically in and of itself, is not attorney-client privileged. The discussion about the lawsuit would be attorney-client privileged. The attorney's billing records would be attorney-client privileged. And it's questionable whether or not the gross amount paid during the litigation, right? The litigation is still ongoing. Very, very questionable, even if the invoice fully redacted just showing the final expenditure of what was spent on the attorney is disclosable until the conclusion of the litigation, if in fact disclosure of that information could harm the case. So it's a very complicated question, but clearly we know that the members, kind of like the United States of America, we can't all run the country, so we elect people to do it for us. Well, we elect a board of directors to make those hard decisions that sometimes we don't all agree with. From the story, I have a feeling there's a lot more to this story than what you're able to tell me right now, because you've taken the time to write a letter to the state, and you feel there's a violation going on there. But I can't quite. Danielle, what do you think? Did you hear the violation in the set of facts that we were given?
Not from what I can tell.
No, the members at a members meeting last week, several of them admitted to the treasurer that they were not made aware of this litigation that was to begin in 2015.
Are we talking foreclosure litigation, or are you talking, Sandy, is it foreclosure litigation, covenant enforcement? What's the general nature of the litigation?
A lawsuit against another owner.
Because they didn't clean their driveway? They didn't clean them up?
No, he's in violation of their co-op docs. He owns 4 units, and in the co-op docs, he's only allowed to own 3 units, and he's owned 4 units in excess of 18 years.
So the board then is exercising its fiduciary duty in enforcing the covenants. I mean, from what you've described, I don't really hear any wrongdoing on behalf of the board that's egregious to me in any event. We elect our boards to run the operations of the business. An association, it's a not-for-profit corporation. It is a business. The board will be doing things. There should be some type of disclosure that we are in litigation, but we can't go into details. Here's what is recorded in the courthouse. Here's a copy of the complaint, the answer, the affirmative defenses. All that the members are entitled to because it's public record. So the members are certainly aware to gain notice that way. But all of the opinion letters from the attorney and the like, and the work product documents during the pendency of the litigation would certainly remain privileged. And even after the litigation, the correspondence from the attorney would. So it's a very interesting set of facts that you've provided, and I don't think we're going to get to a better answer right here, right now. We'll let the division do its job and let them investigate. What else? What other questions did you have?
I think that's it for now. There's too many with this particular community. It's a co-op, and also 4 out of 5 board members were elected to the board in arrears, and one of the board members was elected seated at the time of the election in February. The other 4 were remained in seat by default.
Okay, so you didn't have enough people running.
Right, but we have enough interest now. They didn't realize what was going on in the community and how bad it was.
The association is obligated to hold its annual meeting once a year and to allow the members, to have the election. If you don't get enough turnout, then the board members that are on the board are holdover directors, and they will stay on the board for another year. The board is not obligated to hold another election simply because the members were asleep and didn't timely respond to the opportunity to be on the board.
Right. Oh, you're right. Well, that's not the issue. They were in arrears at the time of election.
Oh, they were. I'm sorry. I thought you said that they were elected to the board. What you're saying is they were financially in arrears in their assessment obligations.
Right.
Something doesn't sound right there, does it?
No, and the state removed one owner that was placed on the board at the time of the election, but opted in that the other 4, that it was okay for them to remain on the board even though they were in arrears because they remained on the board by default, even though they were in arrears.
Right, there was no election, so therefore they weren't in arrears technically when they were elected. But are they delinquent greater than 90 days in any assessment obligation to the association? Because that could trigger a different circumstance.
They are, and I filed the complaint on that, and the state is trying to say that doesn't apply to the co-op.
There's enough what? The state's saying what?
The state is saying it doesn't apply to them because it's a co-op.
Okay, and that may be, and I'll be the first one to tell you that Chapter 719 is the Cooperative Act. And there was a period in my life where I had several cooperative clients, but it's been a while because the cooperatives, no one builds a cooperative anymore. So, many of them convert to condominiums. The law, in some instances, is very different. There was a movement 2 years ago to bring Chapter 719 in a parity with Chapter 718, but not every provision made it in there. And without specifically looking that up, and maybe I can during a break, we can get to the bottom of that particular question. If we have enough time in a break, I can take a quick look in 719.
Hey, Sandy, great questions. We got to go to break. Feel free to call back anytime. Our number here is 888-565-1470. We're going to go to break. We'll be right back with Jeff and Danielle.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
Bylaws.
And we are back. Wow, the phones are just going crazy today. We have another caller on the phone. Let's go to Gloria. Hi, Gloria.
Yes, hello. Is
Hey.
this Mr. Kaye or Mr. Rembaum?
Yes, that was your father's name, wasn't it, Mr. Rembaum?
It was my father's name, but apparently now it's mine too.
Okay. You have a question for Jeffrey or Danielle?
So who am I speaking with?
Jeff
Steve?
Rembaum.
Okay. Here's my question. I hope you can help me with a satisfactory answer. This is regarding limited proxies that were sent out to unit owners to vote on amendments to our documents.
Okay.
There were approximately 6 pages to the amendments. On the first page, it stated an area where if you were going to assign someone to be a proxy holder, that's where you would put their name and your name as a proxy holder.
Right, so you can't make them, for those who don't know, let me interrupt real quick.
Sure.
This is Gloria.
Gloria. So, let me interrupt real quick for the listeners. A proxy. I can't make the meeting, so I give and I sign my right to go to that meeting and vote to Steve-O. Steve-O can vote his conscience. That would be a general proxy. But in a condominium, I direct Steve-O how to vote, because I must according to law. You can only use a general proxy for quorum purposes in a condominium. So I direct Steve-O how to vote. I assume you're calling from a condominium, Gloria?
Pardon me?
You're calling from a condominium, right?
Yes, I am. So the limited proxy on the first page had a section that was devoted to designating a selected proxy holder to take your
place.
The meeting that was designated as to the night to count.
Right. And what happened next?
Okay. And the last page, why I'm telling you this is, in the last page, the 6th page, had another area at the bottom of the page that designated where the unit owner would sign after they checked off which way they were voting on the 6 amendments.
Okay.
Here's my dilemma.
I don't see your dilemma.
Here's the dilemma. Instead of the unit owner signing the page at the end of these 6 proxies that was designated for the unit owner's signature.
Are you saying that on the limited proxy form there was no place for the owner to sign?
Yes, there was. It was on the 6th page.
Well, if it was part of the limited proxy, if it was part of the proxy form itself, that was probably permissible. Obviously, I can't see the form. It's hard to give you...
Here's my question. On the proxy, they did not sign on the designated page 6 where it said sign unit owner, give the number, and so on. They left it blank, and they only filled out the first page, which was designated for selecting a proxy holder.
Are you saying there was no owner signature on the form itself?
I'm telling you where they signed it only. They did not sign it in the appropriate line on the last page.
It could be problematic. I would have to see it, Gloria. I would have to see it.
Area where it said limited.
Gloria. I would have to actually see that form in order to
Happy
give you a
fax
better
notices.
opinion. And sadly, we're not set up to receive the document here so I can actually see it. But it may have a problem. All I can tell you from here is that form
Yes,
may
well,
have a problem.
Well, here's my question, of course, why this is so important. Because if they did not sign on the last page where it's designated your vote as a unit owner, and they only filled out the first page,
Listen, if I
validate the limited proxy.
Well, again, perhaps from what you're describing to me, and I'll use Steve-O as the example. I can't make the meeting. I fill out page 1, and I give Steve-O my proxy, and I sign it, my limited proxy. And then on the remaining pages, I designate on the ballot how Steve-O is to vote. I'm probably not going to sign that last page because that's up to my proxy holder when he turns it in because I can't make the meeting. Steve-O is acting on my behalf.
So I would sign it.
So yeah, you could sign it you would possibly be signing it, but I'm directing you how to do it anyway. So you're basically taking my form and turning it in.
But these, the ones I'm talking about, were mail-in limited proxies. They were not a person who came with it in his hand for the time to count.
I understand exactly what you're saying.
Okay, so this is very important because if those particular limited proxies are not valid, they would lose the quorum. So it's very important.
It absolutely is very important because proxies are so important in helping condominium and homeowner associations to go out and get the vote, and it provides a 90-day period because those proxies themselves, and I know you know this, Gloria, are good for 90 days from the date of the meeting. But whether or not your form, whether it was filled out correctly or not, without being able to see it, I just can't tell you anything more than I already have.
How can I?
There is nothing.
How can I get these pages?
So I really thank you for the call.
Okay, I think we have another. Thanks for calling.
That was a really
Gloria.
good question. The proxies are just such valuable forms and resources for associations.
Well, we have another call. I told you, phones are ringing off the
Tell
wall.
Robert we need to get a fax machine in here so people can send us documents.
Yes. Hey, let's go to Linda. Hi, Linda. Linda?
Linda?
I think Linda, she got tired of waiting. I don't blame her.
Call back, Linda.
Yes. So we were talking about these
credit scores.
Yes. And what are the different opinions of these new assessment reportings?
Well, what's happened is Equifax, which is one of the 3 major credit reporting agencies, entered into an agreement with Sperlonga Data and Analytics, which is a data aggregation business for non-standard credit data sources. And they are trying to take into account community association delinquent payments. How they're going to do that? Well, to me, that's a mystery at the moment. I am waiting with anticipated breath to see how they're going to implement this. And we don't have clear direction yet how it will happen.
But should it be welcomed
they're talking
by
about it.
Community associations?
I think it depends who you ask. I favor it. If I'm paying my fair share in my association and Joe down the street isn't, well, why shouldn't that impact his credit report? Any other debt you have that you don't pay impacts your credit report, so why shouldn't it?
And as it stands now, it doesn't impact their credit now?
Well, not the foreclosure. If someone's in a foreclosure setting where there's records in the public domain, then it could be accounted for and it could show up on the credit report because it's there for the data accumulations, right? The services that are getting this data. But as to the assessment itself, when you're just delayed late and the association hasn't recorded a lien yet, there's nothing in the public records. So how they're going to get this data will be very interesting.
Okay, we have.
Yes.
I'm sorry. Let me just tell everybody we have a line open at 888-565-1470. It's 888-565-1470. If you have a question for Jeff or for Danielle.
I have one more thing to say about the credit reporting. Just like any other credit card payment, if you pay on time and you're regular and you're good making your payments, it's also going to be positively reflected on your credit report. So while a lot of people are saying, hey, this isn't the same thing, you're not providing financing, you're providing services, we shouldn't be socked with a credit smudge on our credit report or get our credit score knocked down for having to pay or having paid late. People will also get a benefit from this. So the arguments are on both sides.
Okay. We were talking also, let's go talk about the classes again that are coming up. We did in the first half of the show.
Sure.
You've got classes
when
coming up.
When are you teaching, Steve-O?
Oh, I'd love to teach a class. It was.
Oh, we ought to have you come and.
Well, we actually filmed.
Yeah.
It was in, I think it was in Deerfield. Yes.
Right.
2 hours, and it was amazing. These were all, a lot of the people, well, there was officers there, but there was also people who lived
Sure.
in the association. Great questions.
You know, you can certify up to a year in advance. So a lot of times the owners like to go to these board certification classes because they're thinking about running for the board. And as soon as you have that thought, well, maybe, that's the time to go to a board certification class, because the certification is good for a year, and you have to do it, either certify one way or the other, within 90 days of being elected or appointed to the board. So you may as well get it over with, because I think it will help it'll help the average person understand so much more. The eyes will become opened as to what the board of directors goes through and the responsibilities and the fiduciary obligations.
So if someone's thinking about becoming a board member, they have, first of all, they have to get certified. Tell me how many hours in a week people normally put into being on the board.
1 to 1,000.
Really?
Really. It really depends on so many factors. There's no bright line answer.
And as a president?
You're probably going to do a little more of the heavy lifting, I would think. But a good delegator will have an army put together behind him so that they're out doing the heavy lifting, and he's accumulating the data and giving the instructions and doing the reporting back.
What about background? What kind of background should someone have who's thinking about running for the board?
Be a human being that is concerned with your community. That's it. Be willing. You know, if you lived in a kibbutz in Israel, everybody has to take their turn in leadership. One day, just maybe, so much of the problems we lawyers deal with, I like to call them the kindergarten rules. If people learned what they should have learned in kindergarten, maybe some of the cases would go away. Well, if you were in leadership of your association and had to deal with these real-world issues, I think if everyone had to do that, I think we'd see a big change in our community associations.
So you don't have to have been like a CEO of a company or ran your own business. And
no,
you know
you can raise your children and do that wonderful job, and then donate your time to the association.
It's funny, I have a friend that just was elected to president, and he said, I've got so many new friends I've never had, but he said, people stop me in the hall to tell me about their problems.
Right.
And he said, but it's wonderful. He said, how can I complain if I don't get active?
Right.
And that's the bottom line.
And so many people complain and don't get active. You raised a really good point, which is why, going back to your original question, we'll talk about Pompano Beach first. The Tuesday, August 23rd, is the Homeowner Association Board Member Certification Class. Covenant Enforcement Class in Pompano, Tuesday, July 19th. Fair Housing Act, everything you need to know about assistance animals, Tuesday, August 9th. Don't miss that class. Guest restrictions and screening, what you can and can't ask to tenants and new owners, Tuesday, July 12th. We are in the process of putting together our new legal update, and we should have some dates for you at the next time we are all together. Palm Beach Gardens Homeowner Association Board Member Certification Class, Wednesday, July 13th and Wednesday, August 10th. The Condo Association Board Member Certification Class, Wednesday, July 20th and August 17th. All the classes are taught in a really unique private setting, so you get a lot of individual time, if you will, with the attorney leading the class.
All free.
All free. All completely free. Except for the gas, I suppose, it takes to get there. But there is no fee for these classes. It's our way of giving something back to the community. Guest restrictions and screening, Wednesday, July 27th and August 24th, again in Palm Beach Gardens.
Well, we're going to go to break. When we come back, I just discovered there's something else that you do.
What is that?
With the associations when it comes to consultations.
Yeah.
We're going to talk about that because I wasn't aware of that.
Okay.
We're going to go to break. We'll be right back with Jeffrey and Danielle. Kaye Bender and Rembaum.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender and Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
The implementation.
And we're back. We are back for our final segment. The firm is, we've got a caller. Firm is Kaye Bender Rembaum. They are association community attorneys. I can say this, they're humble. It's one of the finest law firms in the state of Florida. We have a caller, and I didn't quite get the name. I believe it's
Kelly.
Linda?
No, I thought it was Kelly.
Oh, wrong. There it is.
Kelly. Well, hey, that's what happens when the phones are ringing off the wall. Hey, Kelly, how you doing?
Good. How are you?
Good. Thanks for calling. You have a question for Danielle or for Jeffrey?
For all of you. So I just joined my condo's board of directors, and I must say there are some lovely people on it, but they are not business-minded. So what are some of the best practices for boards you guys would recommend?
Such as, can you hone your question down just a little bit? Because that's a very broad question. We'd start out with going to a board member certification class. Learn how to read a financial statement comes to mind. Treating people the way you would want to be treated is certainly at the top of the list. So let's talk a little bit more about best practices, and let's hone it down just a little bit.
Any of those would be good to go into.
Are you talking about for you specifically? Things maybe you could do to... There's a book by Pete Dunbar. Pete Dunbar is a legislator, or was a legislator. I don't know if he's still up there. But he wrote a really simple, easy-to-understand book about condominium association board member service and homeowner association board member service. And if you go to Amazon.com and you type in the name Pete Dunbar, D-U-N-B-A-R, it's not a paid public announcement. One day I think I want to write such a book. But in any event, he does have one out there, and it will teach you so much. It takes the law and it puts it in plain English. It's a great entry book for any new board member to read. It really is. And of course, come to one of our seminars, all of them.
Okay, thank you so much.
Thanks for calling. See, people want to know.
Yeah, they do.
People want to get involved. And you know what? I would always think, God, you had to be a CEO of a company, owned your own business, and you really don't.
Not at all. Not at all. And in fact, and sometimes we run into board members that don't want to hear from the members. And to those board members who have been doing the service either for one day or 25 years, but if you're in that position where you think the members showing up to the meetings are in your way of getting things done, then it's time to let someone else on the board, as long as there's someone else to come in behind you, because it really is about listening to the residents. And Kelly, that is so important, right? We have 2 ears, 1 mouth. Listen twice as much as you speak comes to mind. Let the members know you are there for them, you are listening to them, and you will be responsive to their concerns. It's so important.
We were just talking how we get a lot of phone calls here from board members that aren't happy with the firm that represents them. And now, will you go out and do a consultation?
Sure. We will go to them. They can come to us.
No charge for that?
We don't charge for our initial consultations, especially, they're interviewing us. They're interviewing other law firms. I don't think it's a nice way to say, hey, thanks for considering us, and here's a bill. So, no, that's just not proper.
There is an election process. Now, I used to be at a big, it was both residential, it was homeowners and association. Boy, the process, the election process, with the badges on them and take them in the back room and beat them up or something. No, but the election process was almost like you're running for a major office.
Well, it's easier to vote for the President of the United States than it is to vote in a condominium board election. It truly is. You have to have an inner envelope and an outer envelope. And if you like to play football, 60, 40, 35, 14, hike, 60 days before the election, you got to get the first notice. If you want to run for the board, give it back to the board, your indication that you want to run within 40 days, within 35 days, right? Give them an 8.5 by 11 and telling them how wonderful you are and why they should vote for you. Then in the 14-day notice package, the association will send that piece of paper along with everyone else that's running. You will get a plain white inner envelope and a larger envelope. You've got to put your ballot inside that little envelope, put the little envelope inside the big envelope, put your name on the outer envelope. You've got to sign it. You've got to have your unit number on it, or it doesn't count. Woo!
That's a lot.
It's a lot of stuff. Or a brand new law. Ink is still wet. It'll probably just start being used in the very near future this year. Electronic voting. So no longer do we have to deal with postage stamps. No longer do we have to deal with, is the election fair? It will absolutely rule out, because they track the IP addresses of the voter, so no one can stuff a ballot box. If you know someone didn't vote, could you vote for them? I mean, I've never seen that happen, but obviously that could happen. That will eliminate that possibility from occurring. Electronic voting is going to be wonderful.
Well, speaking of electronics, we just got a text in.
We did.
Is annual budget meetings required?
You have to have an annual meeting.
You have to have an...
Absolutely. But that's a little bit different than your budget meeting. It's going to depend, when it happens, it's going to depend on your fiscal year. Generally, they adopt the budget 30 days before the new fiscal year will begin, and they do have to adopt an annual budget. Absolutely.
So the answer is yes, you must adopt a budget every single year. Now, there's a way of dealing with it if they don't, but they have the obligation to adopt the budget.
Yes.
Okay. Animal assistance.
Assistance to animals.
This is still the hottest topic, isn't it?
It is, and in fact, maybe the animals need assistance humans.
So explain to everybody, because we have the Fair Housing Act out there, explain to everybody about what is an animal assistance.
All right. There's two different types of assistance animals. If you picture the ADA, and you picture somebody outside your gates, maybe that person cannot see, that would be an ADA service animal, right? You've got the person, he's got the leash, and the dog is guiding him.
Okay.
Under the Fair Housing Act, that animal would be considered a assistance animal with a subset. It provides a service. Then you have the emotional support animal, which is really what your question is. There is no emotional support animal categorization under the ADA. It's only under the Fair Housing Act. So all those people that go spend the money to show that their dog was trained and certified and they have the certificate, like P.T. Barnum said, there's a sucker born every minute, we don't even give those consideration because it's meaningless. What the association needs to know is, does the person have a disability? Does it affect their major life function? Does the animal help ameliorate the disability? Those are the gravamen questions that we analyze and that we look at. Problem is, it's getting abused. That's the problem that many associations are encountering. I know of
with the service animals.
With the assistance animals.
Okay.
The service animal, when you picture the service animal, that's really not going to be abused. When you have a service animal, you have a working animal because you have an impairment. You can't hear, you cannot see, you have epilepsy, and they help detect seizures. Those are service animals. That's a different category than the emotional support animal.
That's the assistance then.
And if you move into a no-pet community, you know, and I'm a huge dog lover for everybody out there. I've had them my entire life: German Shepherd, Dobermans, Dachshund, Siberian Husky, Havanese, and the list goes on.
That was a mix of one of your dogs?
No, that was each
he
dog
has had
separately.
several dogs.
Had many dogs. So I love dogs. But I think if you move into a no-pet community, unless you have a need for a true service animal or you have a real debilitating emotional illness, that, you know what? That was the nature of the community when you moved in.
Right.
And the federal laws, people are abusing these laws left and right. I understand Congress is getting ready to do something about that, but I have a feeling it'll be 5 years at least before we see any action on it.
So again, now on a service dog, a person who maybe can't see, what else?
What do you mean?
What else would constitute a service dog? Problems that you have. It's emotional for
Right.
assistance,
Right.
but for a service dog,
You can't
it's not
see,
just,
you can't hear, you get the epilepsy, you have asthma attacks. The dog
Could be a
lets you know
diabetes
when
dog.
diabetes.
Really?
Yeah, sure. Lots of different functions that the dogs can perform for people that are having the seizures or they go into the acid ketosis.
How would an animal
PTSD
help
also.
a person with diabetes?
They can smell the glucose levels in your breath.
A person who is suffering from diabetes, their breath will smell exactly like an alcoholic. And you'll think the person's been drinking because they're acting almost in that state of mind, but they're not drinking at all. It's the chemical reaction in the body.
Okay.
Medic and
then with an assistance dog, it's just strictly for emotional reasons?
No, there's a subset. There's two different types of assistance animals. The service dog.
Okay.
And that's all those dogs
That's
that
all I
provide the
do.
service. We talked about them. Then there's the emotional support animal. The category of abuse that's occurring is under the emotional support
How do
animal.
you prove that, though?
That a doctor, psychiatrist, psychologist, mental health worker, or any other qualified individual writes a letter. You have a disability, it affects your major life function, and the animal helps ameliorate. And I'm short tracking it a little bit. There's a little bit more to it than that, but that's the general gist of it. And if you meet the criteria, the federal agencies will then get involved as well if the association gives an owner a hard time or asks the wrong question. So here's what I tell my clients. If somebody makes an assistance animal request and you're going to say yes to it, you do not need to bother the lawyer. But if you're going to say no, if you're inclined to ask any question at all, don't do it. Bring it to the lawyer. Board members, you have individual liability when it comes to the assistance animals. Managers and management companies. If a board instructed a manager to say no to the request, if I was a manager, I'd say, I'm not signing that letter. I'll prepare it for you. Here it is. You sign it, Mr. President. I'm not, because the manager can get sued. The management company can get sued. It's just not worth it. Act under advice of counsel. This is one of the only times, Steve, I think you've ever heard me say, go run to the lawyer. This is one of those times. If you're going to say no or ask any questions, bring it to your association's lawyer. Let them guide you.
Give me 30 seconds why someone should hire Kaye Bender Rembaum.
Because in addition to doing this all day, every day, and knowing what it is we do, we genuinely care about our clients.
You can tell.
We are accessible to our clients. I think we do a fair day's work for a fair wage. I think generally speaking, the client base is very happy with the services we provide. We have a great team of lawyers. We take a team approach to problems every day. Michael, Robert, myself, the other lawyers who you haven't met. We are all on the phone sharing ideas, sharing concepts. What would you do here? How would you deal with this? And it's a great informational exchange between us. And that doesn't show up on the client's bill more often than not either.
Give everybody your phone number.
Phone numbers, sure. I would be happy to. In Palm Beach Gardens, 561-241-4462. Pompano, 954-928-0680. And if you're inclined, toll free, 800-974-0680. Ask for me, Jeff Rembaum. Ask for Robert Kaye. Ask for Michael Bender. Ask for your favorite attorney, whoever it may be. We are here to help. We are here to guide.
Give me your website.
www.kbrlegal.com. Robert put you up to these questions, didn't he?
Listen, there was some people who couldn't hang on the phone today, so we missed some phone calls. You guys are with us the first Thursday of each month.
Right.
Great job today.
Thank you for having us.
Thank you for having us.
Listen, and we will be back next Thursday with more Ask the Experts.
And I get more calls than Robert and Michael? Is that what you told me?
You got a lot of calls
All
today,
right,
bro.
well, we'll take it.
We'll see you next week. Everybody have a great week. Peace and love. We're out.
Thanks for tuning in today to the Ask the Experts show with Steve-O and Renee. Tune in every Friday from 4 to 5 p.m. while some of the top local experts in their field from Broward and Palm Beach counties educate you in the areas of law, health, financial, and home improvement. You can also call our offices at 888-574-6999 to become an expert on our show. The opinions expressed on the preceding sponsored program were strictly those of its hosts, guests, and callers, and not necessarily those